Do you have an idea for a new product or invention? It's essential to patent your idea. Patents allow the government to recognize unique ideas and inventions in a way that prevents others from creating, using, or marketing those ideas. The first step is to determine your patent type. There are 3 types of patents that are recognized by the United States Patent and Trademark Office. The first type is the utility patent, which is used for new processes, machines, and chemicals. The second type is the design patent, which is used to protect the way an object looks and is granted for new designs or unique appearances of a manufactured object. The third type is the plant patent, which is exclusively used for both invention and asexual reproduction of unique new plant varieties and hybrids. Once you've determined your patent type, it's important to research and record. It is helpful to show your work at every step of the invention process to justify your patent protection. Try and record as many details about your process as possible, including dates each adjustment was made, research conducted, and the signatures of any witnesses present when developments occurred. The third step is prototyping. It's important to know that ideas alone cannot be patented. Patent applications are granted for those ideas that may be implemented in concrete ways. As a result, it is important to be able to prototype your idea in one of several different forms before submitting for patent eligibility. The fourth and final step is to seek legal assistance. Filing a patent application correctly can mean the difference between an acceptance and a rejection of a proposal. As a result, it's important to have an intellectual property attorney assist you in preparing your patent application. Thankfully, the team at LawTrades can help. Go to lawtrades.com for more information.